Good afternoon, everyone. Let's begin. This is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's Zoominar. In this week's Zoominar, we're in session number 4 of our new and ongoing series entitled the QME Report Writing Masterclass. And I have a great session for you today, particularly as relates to the apportionment section of your report. And I know what you're saying because all qualified medical evaluators feel about the same when it comes to writing their apportionment approximate percentages within the body of the report. And if you're anything like me, I know you probably struggle with your apportionment approximate percentages. And in today's session, we have a special guest and some special ideas and considerations for you in helping you fashion your apportionment argument in the body of your report in such a way that your apportionment approximate percentages will qualify as substantial medical evidence and the case can move forward to a successful resolution based upon your apportionment determination, whatever that may be. So I have a fascinating session for you today, one of which is going to open your eyes to a myriad of new considerations in each and every case that involves a permanent impairment rating for your examinee. I know that when I was researching the content for today's discussion, I had at least 10 aha moments and some revelations about my examinees who I perhaps have not done a full and proper apportionment assessment. But now moving forward, we're all going to have some new tools that we can use to look at these cases to arrive at apportionment approximate percentages that are actually and truly accurate for the facts of the case. So before we get into the topics of today's discussion, let's just go through a little bit of administration. And I'm going to do a screen share here and pull up my screen. And you should all be seeing our PowerPoint screen. Is that true, Mr. Marlowe?
Yes, it is.
Okay. So a little bit of admin. Check the chat for links to your course materials. There's links there for both attorneys and QMEs. Now, what I suggest you do is right now, as we speak, right-click that link and get that link opened in a separate window in your browser. That way, it'll be available for you now during the seminar. It'll be available to you after the Zoominar, and you won't need to follow up with me after the Zoominar to access your course examination. Both attorneys and QMEs are going to receive 1 hour of continuing education credit for today's session. So click that link and get it open now, and you can complete your course examination at your own convenience. During the Zoominar, microphones are muted, and you may not know it or you may not be familiar with Zoom webinars. This is a Zoom webinar. I know everyone's familiar with Zoom meetings, but the Zoom webinar is slightly different, where all the attendees, the microphones are muted. Now, if you have something that you would like to contribute or you have a question that you have for either myself or our special guest, we want to hear from you. And the way you do that is you click the raise your hand button down in the bottom of your Zoom bar. There's a button called raise your hand. And if you click that button, that tells us that you're interested in speaking, and we will get to you and give you the opportunity to do that at the end of the Zoominar. If you have questions during the course of the Zoominar, put your questions in the Q&A. That's also down in the bottom of your taskbar in your Zoom window. Put your question in the Q&A, and we'll address all questions before we conclude the Zoominar. On your course examination, today we have a 4-question course examination. When you successfully answer all those questions, you'll immediately get your certificate of completion. So you might want to go ahead and pull up the course exam right now so that you have it and that you can complete it either now or later. Here's our coming schedule for the next couple of weeks. Today we're on 7/13. Today we have a special guest, Applicant Attorney Jon Marlowe. Next week on Wednesday, the 20th, we have another session on substantial medical evidence. This is a session that you will not want to miss because we're going to get the perspective of the claims payer and the perspective of the defense attorney from a very well-known and very well-respected defense attorney, Attorney Saul Allweiss. So this is a unique and rare opportunity to hear from the perspective of the party that we rarely have an opportunity to hear from. So make sure to not miss that Zoominar. On 7/29 and 8/3, there will be no Zoominars. The reason there will be no Zoominars is because I myself on 7/26 am having a right shoulder surgery. So my right hand is my mouse hand. So I think I'm going to be out of mousing action, but just as soon as we can get back to the Zoominars in early August, we'll have a whole new set of topics and a whole new set of interesting speakers for you. Okay, and that brings us to today's session. In today's session, we're talking about apportionment in general. So we have a special guest who's going to teach us some general principles about apportionment. And then we're going to dive into a specific instance or a specific circumstance that deals with apportionment. And that has to do with examinees or injured workers, whatever you want to call them, who go through medical treatment and at the permanent and stationary date, they have a permanent impairment. And some of that permanent impairment can be traced, even in part, to the medical treatment that they received. This specific scenario happens more than you would think that it does. And you're going to recognize and realize that it happens more often than you ever knew once you turn your attention to looking for this particular scenario in your examinees. So this is dealing with examinees who have permanent impairment, okay? Now, of those examinees that have a permanent impairment, a subset of those will have permanent impairment that's due in part to the medical treatment that they received. And we'll give you several examples of those. And what we're going to share with you today is just a small subset of the potential universe of impairments that are in some way related to the medical treatment that they've received. Now, we only have an hour to discuss this topic, so of course, this is just a superficial discussion. If you want more discussion on this topic, you can get this 6-hour home study course that we have on this topic. It's called the Precedential Cases, and this Hikida case is one of these precedent-setting cases. So if you want more information, we have a deeper dive into this topic in this particular home study course. I'm very excited today because we have a special guest. We have Applicant Attorney Jon Marlowe, who's from the San Francisco Bay Area, particularly in the San Jose and East Bay area. I first met Applicant Attorney Jon Marlowe last year when he was the, I think you call it the president of the local chapter of the California Applicant Attorneys Association. And I had the opportunity to speak for his group, and he was very knowledgeable and impressed me with his passion for representing his injured workers. And I'm so pleased and happy that he agreed to join us today. So I'd like everyone on the call today to give a virtual round of applause to Applicant Attorney Jon Marlowe. Okay, thank you very much. Okay, so let's begin with the topics of today's discussion. So today we're talking about apportionment to medical treatment. And the big daddy of all these cases that we're going to talk about is the Hikida case. And this situation, this scenario, this circumstance is referred to as the Hikida effect. So we're going to first talk about Hikida, and then we'll talk about some second downline generation of cases that deal with similar but not exact scenarios as the Hikida case. And what we're going to see is that these apportionment determinations basically dichotomize down two prongs. They dichotomize down into two basic pathways. So if you can understand these two basic pathways, then when it comes time to provide your apportionment approximate percentages for your examinee who fits in either one or the other of these pathways, you'll have it whipped. So amongst these four cases are the general principles that we can extract and upon which we can rely in the future for doing our own apportionment approximate percentages. Now, we're not going to have a lot of time to get into all the various examples of impairments that can be related to medical treatment, but we'll just introduce here now some examples that are obvious examples from the AMA guides, wherein the AMA guides themselves provide for an impairment rating that's solely due or solely based on the medical procedure that the examinee underwent. So for example, in chapter 16, there's a whole section regarding impairments related to resection arthroplasty. And you're probably most familiar with resection of the distal clavicle in shoulder pain cases. So the AMA guides provide for a 6% whole person impairment rating simply for the fact that the examinee underwent this specific surgical procedure of resection of the distal clavicle. Well, total knee replacement is another example where the AMA guides, just on the basis that the examinee underwent this surgical procedure, the guides provide an impairment rating just for the procedure, just for the medical treatment procedure that they underwent. And there's many, many examples. Probably the most profound of which, if you think about it, is the amputation impairments. The amputation impairments describe an impairment related solely to the medical treatment. Isn't that an interesting thought? I don't know if you're all as impressed by the profound revelation of that as I am, but this is a whole new way of thinking for me, and I'm suspecting that it may be the same for you. So these are some examples that neuromusculoskeletal evaluators are familiar with, and you can take a look at these in the AMA guides. At the end of today's discussion, we have Attorney Marlowe. He's going to talk to us about some considerations that we may not often consider, but it's very top of mind consciousness for applicant attorneys. And that has to do with the effects of medication and other side effects of medical treatment, such as deconditioning, such as weight gain, and applicant attorney Marlowe is going to share with us several of those. Okay, so that's our agenda for today. Now, in order to fully understand this concept known as the Hikida effect, it's important that we review a couple of basic principles about apportionment in general. So Attorney Marlowe is going to pick it up from here and discuss a few things for us about apportionment.
Thank you. So with any aspect of workers' compensation, everything starts with the basis of the law, the labor code. Then we have real life experiences, and then we have case law that we're going to discuss later that sort of helps us interpret the law and realities of what you as QMEs and us as attorneys are seeing in injured workers. But Labor Code 4663 is one of the apportionment laws. In regards to it, it says that as a QME or in the workers' compensation realm, there has to be the physician must address or shall address causation of permanent disability and determine whether or not there's a percentage of that permanent disability that is caused by other factors other than the industrial injury itself, including prior industrial injuries. Some of the key points about the Labor Code 4663 regarding apportionment is it does contain the word shall, and that is a imperative command that the QME must address apportionment. It does not mean in any way, shape, or form that the QMEs or the med-legal evaluators shall apportion impairment. It's you must address apportionment. And then in regards to the causation, we have to keep in mind that it's not causation of the injury. It's not how the pre-existing injury predisposed the person to the industrial injury. It's the outcome of the industrial injury, the cause of disability. And the key things to think about are what are the direct and indirect causes of that disability? So direct causes would be stemming from the injury itself. Indirect causes would be stemming from potentially medical treatment, as in the Hikida case, or it could be pre-existing conditions. And so that's where understanding and evaluating the pre-existing pathology, and then subsequent what the final disability is very important. But the key thing is to understand that the medical treatment for industrial injury is not apportionable. So the employer is responsible for treatment and consideration of the entire injury, but what they are not responsible for is any disability caused from those, quote, other factors that were pre-existing the industrial injury. So keep in mind that aggravation of industrial injury or infliction of the new injury resulting from its treatment or examination, they are compensable in the subsequent form. And apportionment is where it becomes critical that the analysis is in detail.
Okay, so just going back real quick, go back one slide. Sometimes I get questions from qualified medical evaluators about how do I know? How do I know what are my apportionment percentages? In other words, how do I know if it's 80% due to the industrial injury and 20% due to other factors? Or how do I know if it's 70-30 or 60-40? I mean, how do you actually come up with the number? What is the number? Well, fortunately for us, built into the law is the phrase approximate percentages. And I can only assume that at the time this labor code was rewritten around 2004, I believe it was, legislators must have understood the difficulty that qualified medical evaluators face in coming up with their apportionment percentages. So the law here, by its language, has built into it some flexibility for us by allowing us to use the phrase approximate percentage. So when you're fashioning your apportionment argument within the body of your report, you can use this phrase to your advantage by saying, for example, in my opinion, approximately 20%, approximately 20%. And that's consistent here with the language of the law that allows you to use approximate percentages. So don't feel that you have to nail down an exact percentage. You're allowed to use approximate percentages. However, you have to provide an exact number, okay? So let me elaborate on that. It used to be, because I knew that we were allowed to use approximate percentages, I used to provide a range. So I used to say things like, in my opinion, approximately 60 to 70% is due to the industrial injury, and that's not sufficient. So you're allowed to use approximate percentages, but you need to give an exact number. Would you concur with that, Attorney Marlowe?
Yes, but I believe that's a predicament that the med legal evaluators are always under is how do I determine an approximate percentage? And it's kind of a artistic feel, but based on the evidence presented and the reports and the records and the examination, you know, that's your job. But yes, it has to be an approximate number.
Okay, so let's continue. So key point that Attorney Marlowe pointed out is that the infliction of a new injury resulting from the treatment or the examination are compensable. Now, I know you understand this, and let me just give you a simple example. This happened, I had this type of an examinee. I had an examinee who had an industrial lower back injury, and he was attending a medical appointment on a Friday afternoon for his industrial injury. And as he left the medical office and began to merge on the freeway, he was rear-ended from behind and suffered a cervical spine injury. So the cervical spine injury is the infliction of a new injury. The cervical spine injury is compensable under the original injury. The cervical spine injury constitutes the compensable consequence injury that's related to the medical treatment that he was receiving for his industrial lower back injury. Can you see how these Hikida examples are actually all around us if we just open up our consciousness to them. So this is the concept of the compensable consequence injury. So let's talk a little bit about that. So again, these are the key phrases from California workers' compensation: that infliction of a new injury resulting from its treatment or examination are compensable. So I know you're familiar with this phenomenon, and you probably notice these passages in the cover letters that you get all the time, but you may not have paid particular attention to them. So here's a passage from an actual passage from a cover letter that I received from an applicant attorney, and this is similar to the ones that you get all the time. It says, this would be in the causation section of the report. In the discussion, it says, what is your diagnosis of any disabling condition found? Now, if I was going to write this letter myself, I would probably put the letter S after condition in parentheses, condition or conditions, to better prompt the QME to consider the myriad of conditions. And then she goes on and she asks, are there any other conditions found that can be considered a compensable consequence of the industrial injury? For example, gastrointestinal problems, sleep disorders, sexual dysfunction, psychiatric disorders, problems with opposite limbs, as well as any condition secondary to the use of prescription medications, reflex sympathetic dystrophy, CRPS deconditioning, et cetera, et cetera. And this is the applicant attorney's prompt to us to consider the entire spectrum of impairments that the examinee could be suffering from, including those impairments that constitute the compensable consequence injuries as a result of the medical treatment that they've received. So if we can spot these compensable consequence injuries and the results impairment from them, the apportionment of that permanent impairment in some cases could be unapportioned. In other words, the impairment could be unapportioned. The examinee could receive the entire and full benefit of the permanent impairment unapportioned if we can first spot and identify the scenario of the examinee who has an impairment due to the medical treatment that they've received. And if you review the AMA guides, almost every chart, almost every table, almost every graph, almost every discussion of impairment that you see within the AMA guides is an impairment that could be due to the medical treatment. Isn't that unbelievable? I've never thought of it that way. But if you look at the charts and tables, you realize that, hey, this is something that could have been caused by the medical treatment, not just the industrial injury, could have been caused by the medical treatment. So that brings up the Hikida case and the downline series of cases that illustrate our operating principles in this particular scenario. So Attorney Marlowe is going to share with us 4 cases to help us develop these principles. Okay, Attorney?
So the Hikida case really upended everybody's perspective on apportionment. In this situation, the background was that the injured worker filed a claim and was receiving medical treatment for a carpal tunnel injury and had carpal tunnel release surgery. Following the carpal tunnel release surgery, the injured worker developed chronic regional pain syndrome, or CRPS. Based on the reporting from the QME, there was pre-existing pathology, and the QME apportioned 10% non-industrial, but however found, based on the carpal tunnel, the CRPS, the injured worker had 100% disability produced or from the carpal tunnel, but then apportioned 90% industrial and then 10% non-industrial. The case was then taken up through the appeals process, and it was concluded that the disability caused by the chronic regional pain syndrome was 100%, and it was derived from the medical treatment and not the initial injury itself. It was something that was unforeseen. This is sort of creates this intervening act. So this person had carpal tunnel syndrome. You would expect a successful recovery following a successful release procedure. However, there were complications that were developed from the surgical procedure itself, and that act of the surgical procedure creating the CRPS is the intervening act, or sort of breaks the connective chain between prior pathology to the new disability. And it was concluded that the injured worker had suffered 100% permanent total disability, and that was the final award. And it was based upon the CRPS that was developed from the surgical procedure. So following that, the Hikida case, there's been subsequent cases, and I want to just keep in mind that the cases that we're going to go through here are a story of to where we are today. But initially in the Klein case, this is a person that had a pre-existing degenerative, pre-existing arthritic condition in the knee, and then following his industrial injury required total knee replacement. In that case, it was found that the judge concluded that the pre-existing degenerative changes were removed with the prosthetics that were in place with the total knee replacement, so that there was no prior pathology. That pathology had been removed, and thus apportionment wasn't applicable to that injured worker's final rating of impairment. So when everybody on the applicant's bar saw the Klein case, we really thought, okay, great, every total knee replacement is non-apportionable. However, as you'll see in the subsequent cases, we get some dicta from the court on what's appropriate and what's not appropriate. So next slide. So in the Gallego case, this was another total knee replacement case, but this one, the court concluded that there was pre-existing degenerative changes, and the issue here was, ironically, that the QME did not create substantial evidence in their documentation of apportionment. And so the defendant argued that the pre-existing knee problems contributed to the need for the total knee replacement. And so here, we had the prior case in Klein. They said, the court said, well, the arthritis was removed in the procedure and no longer existed, so you can't apportion to that. And then in the Gallego case, they said, well, wait a second, there's pre-existing pathology that contributed to the need for the surgery. And so now we had a Hikida looking just from the end of the case when the person was permanent stationary, and now Gallegos makes us have to look through the entire case, what is leading up to the need for surgery prior to the surgery, and then contemplating what is the outcome post-surgery. So next slide. And again, to just elaborate, Dr. MacGyver, who was the QME in this case, he cited to the medical records, which were quite considerable, with quotes, with ongoing problems. So this person was receiving medical treatment for their osteoarthritis in their knee. And so the pre-existing degenerative changes were ultimately, they were going to require a total knee replacement in essence, regardless of the industrial injury. The industrial injury in this situation, most likely, again, I'm making an assumption here, most likely sped up the need for the total knee replacement in this applicant. But again, the Gallegos case establishes that pre-existing condition may be apportionable if it's a causative factor in requiring the surgical procedure. And then we come to the justice case. This is a local case. I know the QME fairly well. That was the QME, Dr. Anderson, on this case, and I also know the applicant attorney and the defense attorney. And this was somewhat solidifying the prior Klein and Gallegos cases and summarizing all together. But the key takeaway from this case, the court wrote, Hikida precludes apportionment only where the industrial medical treatment is the sole, that's the key word, sole cause of the permanent disability. So as I was discussing previously in those total knee replacements, they were, the initial thought was, well, there's a total knee replacement, the arthritic condition's been removed surgically. And then going forward, they said, well, wait a second, the total knee replacement, part of that arthritic changes in pathology prior to the industrial injuries drove the need or had some causative factors to the need for the medical treatment. And so here in the justice case, we get back to, it kind of takes us back to a clearer meaning of Hikida and says that the medical treatment is the sole cause of the permanent disability. And so here we have to find that it's not entirely, in this case, they found that it was not entirely caused by the industrial knee replacement. And so based on a person's medical history, it gets to the point where you have to consider the mechanism of injury, the prior pathology, and then the treating physician's analysis of why do I have to take this person to surgery? And unfortunately, as AMEs and QMEs, you're not getting detailed records from reporting from the doctor stating, I'm taking this person to surgery for a total knee replacement because the pre-existing arthritic condition and the industrial injury require me to perform a total knee replacement. That is something that's left on your shoulders to make that judgment. But the key thing here is to understand that you have to, as a QME, understand what's the pre-existing pathology and then make a connection to, does that pathology contribute to the need for the surgery? And if so, there is a portionable amount of the final impairment back to the pre-existing pathology. And as I stated before, there's direct and indirect causal factors, and the indirect and direct causal factors are now, as Dr. Carpenter was mentioning, the two-prong approach, in my opinion, is what's the direct and indirect causes leading up to the need for surgery, and then subsequent, as the patient or injured worker becomes permanent and stationary, what is the direct and indirect causes of the impairment?
Okay. So let's summarize this a little bit. So let's summarize this. We have 4 cases. We have Hikida, we have Klein, we have Gallegos, and we have the justice case. And all of these cases, each of these examinees suffered permanent impairment as a result of the medical treatment that they underwent. 3 of those were knee replacement cases as examples, and you can think of any number other types of medical treatment impairments, but these are knee replacement cases. So all of them suffered permanent impairment as a result of the medical treatment, okay? Now the nuance between the Hikida case and the other cases is that in Hikida, her impairment was able to escape apportionment, whereas the others, especially justice, was not able to escape apportionment. Hikida was able to escape apportionment because her impairment was due to the chronic regional pain syndrome, which was solely and entirely caused by the medical treatment. Okay. Now, in the other cases, the injured workers had an impairment due to the medical treatment. The impairment was due to total knee replacement, which has a specific rating in the guides. But other factors were found to contribute to the need for the knee replacement. And there was no compensable consequence injury as a result of the knee replacement. So unlike Hikida, those other knee replacement cases did not have an impairment solely and entirely due to the medical treatment as a compensable consequence injury. There's a little nuance there, but if you can understand that nuance, it gives you the two basic pathways that these cases can take, okay? Now, another consideration could be, what if those knee replacement cases, okay? So we have a knee replacement case with pre-existing degenerative changes, and there's some apportionment to the pre-existing degenerative change. And then imagine if that knee replacement case then developed a gait derangement. Imagine if that knee replacement injured worker developed weakness, developed a foot drop, developed some other impairment as a result of the knee replacement, then that would bring that situation, and chime in, Attorney Marlowe, if this is incorrect thinking, but it seems to me that that would bring that situation more over into the Hikida type of situation where that additional impairment could escape apportionment. Do you have a comment on that, Attorney Marlowe? Because I have a couple of other examples as well.
Yeah, no, that's a great example. And I think what we'll get into later in the presentation, but a little preview is that if a consequence to the surgery is something that is not anticipated, then the bell should be ringing, is this consequence apportionable? And then as the part of the two-prong approach, is drop foot something that's normally caused by arthritic changes in the knee? And I'm not a MD, and I would argue it is not an anticipated consequence or outcome for arthritic knee changes to have drop foot. So the one area that might get a little trouble on would be gait derangement, because arthritic changes in the knee is reasonably anticipated to create gait derangement or gait changes potentially. But drop foot, as an example, that would not be something that is normal for somebody with arthritic knee changes, so it would not be apportionable. So.
Okay, perhaps as another example, and this is just to illustrate the principles. There's probably any number of examples, but imagine an examinee who has a shoulder surgery, and the shoulder surgery, lo and behold, involves the specific procedure of a resection of the distal clavicle. Well, the AMA guys provide a specific impairment rating for a resection of the distal clavicle. It's 6% whole person impairment rating. Now, imagine that after the shoulder surgical procedure, as a result of pain, disuse, favoritism, what have you, the examinee develops a frozen shoulder. It goes from bad to worse. Well, with a frozen shoulder, imagine that the frozen shoulder fails to fully resolve, and the examinee is left with some impairment due to abnormal motion, okay? So this new impairment, okay, so we have two impairments. We have a resection of the distal clavicle. We have an impairment due to abnormal motion. This impairment due to abnormal motion, you could argue, is due solely and entirely to the medical treatment, which was the resection of the distal clavicle, the shoulder surgery procedure, in which case this impairment, the impairment due to abnormal motion, not the impairment due to resection arthroplasty, but the impairment due to loss of range of motion, could escape apportionment, similar to Hikida, who developed CRPS. Here we have an examinee who developed frozen shoulder as a result of the medical treatment. And these examples are infinite if we could just open our consciousness to those. Similarly, if the examinee developed loss of strength in the shoulder where there was no medical evidence of loss of strength prior to the surgical procedure, you could argue that that portion of the impairment is unapportioned. And there's many other examples as well. So let's go over some general principles. So the additional impairment, this compensable consequence injury impairment, can escape apportionment, can be unapportioned if the disability is caused by the medical treatment. If it's a separate and distinct disability or impairment that's caused by the medical treatment, that can escape apportionment. When the disability derives from the medical treatment, where like Hikida, the treatment causes a compensable consequence injury, and that injury results in an impairment, then again, there would be no apportionment. And here's some of the key phrases. If your examinee follows this pathway, here's some of the key phrases that you want to employ in your apportionment description. If the PTD, permanent disability, derives entirely, this is the word you want to employ, entirely from the effects of the compensable consequence injury, then there would be no apportionment. If the industrial medical treatment is the sole cause, there's your two key phrases, entirely and sole. So if it's the sole cause of the permanent disability, like in Hikida, the surgery was the sole cause of the chronic regional pain syndrome, then again, that impairment would be unapportioned. So if this is your opinion, then you must describe how the current disability is separate and apart from the disability that's due to the underlying industrial injury. And it seems that that wouldn't be all that difficult to do once you get very, very clear on what it is that the impairments actually are. So the first step in an apportionment discussion is to be very, very clear on what are the impairments that you're apportioning. Now, the other prong that involves valid and legal apportionment is if there's a pre-existing condition or there's underlying pathology, and the pre-existing condition causes or contributes to the need for the medical treatment or the surgery perhaps, and as a result of the medical treatment, no new compensable consequential injury occurs, then there would be some apportionment, at least some apportionment to the pre-existing pathology, which may be justified, and it would be your job to determine what is that approximate percentage to be due to the pre-existing condition. So it seems to me that if we open our consciousness to this concept, we can see that there are indeed new compensable consequence injuries that result from the medical treatment. And similar to the shoulder example that I talked about just a minute ago, similar to our shoulder example, you know, how many examinees suffer a loss of range of motion? Couldn't it be that that loss of range of motion is due to the treatment? What if the medical records show that before the surgery, range of motion was normal, but after the surgery, there was a loss of range of motion? That portion of the impairment could pass down pathway number one and escape apportionment through pathway number two. Okay, so there's just some ideas for you. And now Attorney Marlowe is going to share with us some considerations that neuromusculoskeletal evaluators like myself may not have considered, having to do with some other internal medicine aspects. So I'll have you take it over from here, Attorney Marlowe.
So in evaluating these injured workers, as an applicant attorney, I know in my cover letter, I always say take a full history, provide diagnosis of all injuries and or conditions, and then determine what are industrial. But as evaluators, there are things in regards to internal medicine issues and effects of medication that need to be or considered at least and evaluated. And so this is obviously most med legal evaluators go through an interview process with the injured worker and may or may not be asking them, do you have any GI issues, or do you have any side effects from the medication? So considerations and things to consider when you're evaluating injured workers are what particularly internal medical conditions or medication side effects are present before the industrial injury. So did this person have a chronic history of irritable bowel syndrome or gastroenteritis or GI issues or GERD? And if not, is there a particular medical internal medical condition side effects if they are, were they disabling prior to the industrial injury? So that's kind of getting the pre-injury history of the injured worker to figure out were they having issues, internal medicine or medication side effect issues. Obviously, this is sometimes found out in the medical review of the medical records. Sometimes it's found out during the interview, but it's obviously questions like, have you been taking regularly taking any medications, and if so, what are they? And then do they cause you any side effects prior to the industrial injury? But the key things to consider in evaluating whether or not the industrial injury has caused any issues in internal medicine or are there side effects to the medication is understanding the but-for questioning. So but for the industrial injury, would the internal medicine condition or medication side effect be disabling? So this kind of leads into, but for the treatment for the industrial injury, would the internal medical condition or medication side effect have existed? So going to the total knee replacement example that we've discussed in the case law regarding that, if somebody has not a successful, but a moderately poor result from a total knee replacement, and then now they're prescribed prophylactically some narcotic pain medication, they've developed some GI issues, that gets into this line of question. But for the total knee replacement outcome, they're now taking these pain medications, and does that individual patient, do they have pre-existing disabling effects of medication? If not, then it could be something that is an additional impairment, and that additional impairment is not apportionable. So keep in mind that you have to consider the factors other than treatment for the industrial injury that cause a permanent disability, and if it's coming from an internal medicine perspective or effects of the medication. Keep in mind, in the end of the chapter of the guides, I always tell AMEs and QMEs that I meet with, read the definition section, because the effects of medication, there's a 1 to 3% impairment rating just on effects of medication in the end of the AMA guides in the glossary section. So it's a little fun fact tip for y'all. But also consider, is there any effects being caused from the treatment of the industrial injury, such as MI events, cardiovascular, deep vein thrombosis? Deep vein thrombosis might be somebody who has a total knee replacement procedure done, becomes sedentary following the knee replacement for some time, and develops deep vein thrombosis. Is that something that's being examined by the evaluators during their med-legal exams? So next slide.
Okay, so before we go on to the next slide, so just a quick question on this. So, I'm a neuromusculoskeletal evaluator, so internal medicine issues are interesting to me, but I'm not that familiar with them. So let me ask, does a medication side effect, does it have to have an impairment rating for it to follow along these lines of the Hikida effect? So something that has to be a rateable condition?
Great question. And again, per the guides, there's an I would say a novice way to rate effects of medication, and then there's the advanced way, which would preferably be done by an internal medicine QME. But the novice way is again in the glossary section of the AMA guides. It's the liberty of the evaluator to provide 1 to 3% impairment due to the effects of medication. So these effects could be I have to take the medication before I go to bed because I sleep, or it makes me nauseous. I have to I get a headache from the medication. Those are effects, and whether or not the headaches, the sleep disturbance, or concentration is rateable you still have the glossary to turn to allow you to give 1 to 3% impairment due to the effects of medication.
And would that be in addition to any discretionary impairments, such as the pain-related impairment and the DRE bump up to the higher category? Would that be in addition to all of those?
Correct. It's in addition to pain and DRE ratings and ratings for the body parts.
Okay, so would it be safe to say that we're probably missing many of these impairments for examinees who are actually having medication side effects?
Yeah, that's quite possible. And again, that goes into the importance of the interview and getting the detailed history prior to and post industrial injury and treatment.
Okay.
So as I was discussing, some of the things to think about is injury requiring them to take prophylactic ibuprofen, then maybe they have gastritis. Are they on narcotic pain meds? Is that creating GERD? And also to keep in mind that a lot of these patients, due to pain as being a stressor, and in addition to the pain effects of the medication, they could get hypertensive. And so a lot of times, the clients I like to make these arguments with, who get detailed evaluations by their physicians on a regular basis, through, like, for instance, through Kaiser, who have, consistent blood pressure measurements, and we can document that post-injury, post-treatment, post-medication have increases in their blood pressure. We can make those arguments. So again, that's when you're going through and getting your performing your physical, see if they're hypertensive, and that might be due to the pain from the injury or side effects of medication. And then obviously diabetes. This is it's pretty contentious amongst the sides of the attorneys and both the applicant bar and the defense bar. But a lot of times we see injury, weight gain, stress leads people into pre-diabetic stages, or increases or elevates their pre-diabetic stage into a more severe case of diabetes. Also, other things to consider are the weight gain and deconditioning. Again, a lot of times the primary treating physicians, they're not taking or they're not weighing and taking blood pressure measurements on the applicant on a regular basis for every, not performing the basic physical exams, like and collecting that data, but asking the patient, how much weight have you gained since your injury? What has been your activity since the injury? And so, but for that treatment, would this weight gain deconditioning have occurred? So again, going back to a total knee replacement, or even a lumbar fusion case, if they severely reduce their activity levels, gain weight, become more lethargic, there definitely could be a rateable impairment due to this. And understanding, has it caused other medical conditions like the hypertension, diabetes, and even atrophy? That's the one thing I ask a lot of the physicians, the AMEs and QMEs on my cases, is to measure the major muscle groups distal from the affected industrial injury area.
Interesting.
In regards to summarizing this all up and sort of understanding how Hikida has impacted the med-legal realm of workers' compensation in the state of California, not all of you are going to see that case where it was a carpal tunnel case, post-carpal tunnel release generates CRPS. But the key thing is the current impairment, or has an injury occurred, an additional injury or additional impairment that's separate and apart from the original original industrial injury? Or otherwise, is it something that you could have predicted would be an outcome, a natural outcome from that injury? So total knee replacement develops drop foot, is that something that's anticipated and predictable from a total knee replacement? Most likely not. And so then the approach has to go, but for that surgical procedure would the person have developed drop foot, and then determine whether or not apportionment is applicable. But keep in mind, in regards to Labor Code 4663, all med legal reports must or shall address apportionment or causation of the impairment. It does not mean all QME reports or AME reports must include some apportionment. It commands all the evaluators to address it. And keep in mind that an employer is responsible for both the medical treatment and any disability arising directly from unsuccessful medical intervention without apportionment. So this is the statement that was made in the earlier cases, which did the medical treatment break the chain or the causal connection with pre-existing pathology? So in the Hikida case, there was some pre-existing pathology of carpal tunnel syndrome, but due to the carpal tunnel surgical release procedure, that injured worker then developed CRPS, and that event of the surgical procedure causing a new injury broke the chain connecting it to the pre-existing pathology. And so again, Hikida is a big case. The attorneys were going after 100% total permanent total disability. But the key takeaway is from Hikida, if there is a break in that chain, it's not apportionable. The causation is due to the medical treatment and is something that unless there were issues that we're talking about, like in the total knee replacement, where there was a natural cause from the underlying pathology requiring the surgery, but if there's some unexpected outcome following the surgery, per Hikida, it's unapportionable.
Okay, what a workout. Fascinating stuff. So I think the takeaway for me on this is that in every case that involves a permanent impairment rating, it's important to look at the totality of the permanent impairment rating and all of the aspects of the permanent impairment rating and determine if any of those aspects can be traced to the medical treatment. And if the medical treatment, if you can argue that the medical treatment is the sole cause or the impairment is entirely caused by the medical treatment, then at least that aspect of the impairment would be unapportioned. So that's something for us as qualified medical evaluators to pursue in each and every evaluation. Okay, so let's go to the questions. We have a couple of questions. Take these one by one. One attendee says, if we had a knee replacement with a residual gait derangement, or a drop foot, would we use the combined values chart or addition? Oh, this was last week's Zoominar on the kite analysis. So would we add those impairments or would we combine those to get the total whole person impairment? Attorney Marlowe?
As an applicant attorney, I always advocate for kite, the addition. But if you take a gospel approach to reading the guides, it's in the same body region. And unless there is no overlap in the impairment or the function, it should be combined.
Should be combined under the strict application of the guides. So a knee replacement is one of the diagnosis-based impairments. And according to the cross-usage chart, those cannot be combined with impairments due to gait derangement. So under the strict application, the answer would be no. Is there any application that you can perceive where those impairments could be added?
Again, so the drop foot to the knee replacement, it depends. I mean, again, it would be, again, according to the four corners of the guides, if the evaluator determines that the effects of the drop foot and the gait derangement are magnifying in some way, then the evaluator has the liberty to state that the most appropriate and accurate rating of disability is adding or even multiplying the two ratings.
Even multiplying. Okay, next question. This is from one of our attorneys in attendance. He says, for a patient who has an outcome with increased functional loss, totally independent, or totally caused by the treatment for an industrial injury, should that patient also consider that the treatment was improperly performed, or that the release for the surgery was incomplete, and the attorney should consider a malpractice? Oh boy, should consider a malpractice claim. I don't know. Is that beyond the scope of this discussion?
Yeah, I mean, this would be more towards an audience of applicant attorneys, but you know, in our practice as applicant attorneys, we do have to have our eyes open for ancillary third-party claims such as malpractice. And so, if that were the outcome of a patient of mine, in order to keep my professional P&L insurance company happy, I would need to refer that person out to a malpractice attorney in that situation. Whether or not they have a case, that would be determined by the malpractice attorney. But.
Okay, and then finally, someone asked, aren't many of these IM conditions reversible? I'm assuming IM stands for impairment?
I believe that's internal medicine.
Oh, internal medicine conditions reversible and therefore not permanent. Okay, I get it. And therefore not permanent impairments. I defer to you on that since it refers to internal medicine.
Well, again, I'm not an internal medicine physician, but you know, the internal medicine, there are some I found in reporting from some of the internal medicine evaluators out there that they are permanent. You are right, some of them are transitory. So if the person stops taking the medication, the IM conditions will go away. But in some cases, again, it's true that they are sort of reversible, or it would go, the condition would go back to baseline. However, if that patient is going to be taking those medications prophylactically, and they have been taken for a long course, and the treating physician is saying that this person's going to need to take, you know, Norco for the foreseeable future, then they aren't necessarily reversible. It's going to be a prolonged permanent issue.
Right. And we would just provide our opinion based upon the prevailing medical record status of the injured worker at that point in time. That would be all that we could go on.
Yeah, and that's the other point is, as evaluators, you know, you're evaluating at a snapshot based on your physical exam, the records coming to you that lead up to the exam that you perform, and you're evaluating them. You know, you're taking the patient as they come. So at that moment in time, if they're having IM issues, then they're having IM issues.
Okay, last comment comes from the chat. So one doctor says, as a musculoskeletal evaluator myself, therefore, so I can use the 1 to 3% additional rating due to the effects of medication, as long as I provide the how and why I made the conclusion in the permanent impairment section of the discussion. So if so, I just refer the reader to page 600 of the guides and quote effects of medication that is found in the glossary. So he's asking how to substantiate his opinion for an additional 1 to 3% impairment rating due to the effects of medication. So do you have a step-by-step for us on that?
Yeah, I mean, the how is the patient is taking, you know, is being prescribed medications A, B, C, or as such. These medications cause certain types of impairments, or, you know, disruption of sleep, loss of focus, cause bowel irritation. And so that's sort of the how and the why. that I ask the physicians in my cover letters is, are there effects of medications? Please describe the medications that the injured worker is being prescribed. And then please describe how these medications are affecting the injured worker or the applicant. And then what, if any, effects that has on the person's ability. Right.
Okay, so I think that's all of our questions. So let's conclude today's session. So first of all, I want to thank you, Applicant Attorney Jon Marlowe, for joining us. I speak on behalf of the entire group. This is a very educational and enlightening presentation for us, so thank you very much. I know that my evaluations moving forward are going to be much different, and I'm sure the doctors in attendance are going to have an open awareness to some of these additional impairments as well. So in conclusion, doctors, I want to thank you for taking the time to join me on this week's Zoominar. Look forward to being with you on future Zoominars as well. And I want to thank you for your commitment to excellence. I want to thank you for your commitment to ongoing and continuous learning. And I want to thank you for your personal contribution to improving the integrity of the QME program. This is Dr. Perry Carpenter, and on behalf of Applicant Attorney Jon Marlowe, we're wishing you best of success in your careers as qualified medical evaluators.
Thank you, everybody, for attending, and thank you, Dr. Carpenter, for asking me to help you out in this presentation. It was very enjoyable.
Thank you very much. Bye, everybody.